right hand to be sworn in by the court.
Do you solemnly swear or affirm that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Thank you.
Good afternoon.
Good afternoon, sir.
All right, thank you. Could you please introduce yourself to the jury?
Yes, Danny Peters, D-A-N-N-Y, P-E-T-E-R-S, detective with the Polk County Sheriff's Office.
And what division do you work in?
I'm with the Homicide Division.
In this case, are you the case agent, the lead detective?
I am.
Tell the jury about your education, training, and experience.
In 2010, I went to the Basic Law Enforcement Academy. Upon graduation, I was hired by the Polk County Sheriff's Office, where I've spent 14 years, most of them in investigations, and led me to this point.
Now, when you investigated this case, had you been in the homicide division for a certain period of time?
Just several years.
And have you investigated countless homicides?
Yes.
How did you first get called out to this case?
We were notified by supervision to respond to a death investigation.
And do you recall approximately what time you arrived on scene?
7:25 approximately.
And was that actually to the crime scene, the residence?
Yes, sir.
And that's in Polk County?
Yes.
Describe to the jury kind of your mentality as a homicide detective when you get to a scene. What's it like?
Well, initially when you get to a scene, it's a little chaotic. You make contact with deputies on scene, and you learn what they responded to and what they heard upon their arrival.
Now, about how many detectives might be working a case, like this case particular, how many detectives were working at the same time you were? Or was it multiple detectives?
Multiple detectives. We had more than 5.
And do each one of you kind of have multiple things that you're investigating?
Yes, we have different tasks when we're on scene.
And then how do you get updates from each other to see where the investigation is at or where it's headed?
So through the course of the investigation, we tend to come together and brief each other in reference to what we've learned, any evidence we've obtained. We call each other on our cell phones and explain where we're at and what we're doing.
What's the crime scene / forensic investigator's role at a scene?
They're to arrive and preserve evidence for us, document evidence.
And I take it they were present the night of?
Yes, sir.
And do they kind of work on their own, or are you as the lead detective telling them what to do or what to look for? How does that work?
No, so as a detective, I give them direction in reference to stuff that I'm looking for or things that I need, as well as the other detectives on scene also give them instructions.
So when you show up on scene, do you know where the defendant was?
From what I was told, the defendant was in the back of a patrol car.
So is it a fair statement you were not interacting with him at that time, but rather were then surveying the scene?
Correct.
Describe to the jury what you did.
So upon arriving, I made contact with the initial deputy who briefed me of what he encountered upon arriving. And then once I learned that information, we made contact with the medical examiner to explain exactly what it was that we had on scene. And the grandmother arrived on scene, and then we began to do our interviews.
Did you have an opportunity to actually speak and interview the grandmother, Susan Detman, that evening?
I did.
And was that a one-time thing, or did you interview her any additional times after the night of September 8th?
Yeah, I interviewed her again after the initial night we were on scene, yes.
Now, and she was / is the owner of that house, correct?
Yes.
Did you have an opportunity to go inside the house to see what was going on inside?
I did.
And was Kathy's body still there when you were there?
It was.
Now, you mentioned that you spoke to the medical examiner. In this case, did you speak to Dr. Garavan?
Yes, it was Dr. Garavan that was the on-call medical examiner, yes.
And explain to the jury about why you called him and what you were hoping to learn from.
So I explained to him the manner in which we found the decedent and the severity of her injuries, and he was giving me an explanation of the probability of what may or may not have happened.
Would the medical examiner then the next day do an autopsy?
Yes, he did.
What did you notice that caught your attention about the crime scene, both outside and inside?
Well, I noticed it was well organized. It was clean. Outside, the victim and the defendant's vehicles were parked at the residence, and then inside was very organized.
Did it appear that there had been a long, drawn-out fight of any type?
No.
Now, as part of any homicide investigation, do you obtain evidence from cell phones?
We do, yes.
Now, when there's a cell phone of interest or that may be relevant for a certain investigation, do you have professionals who are able to do forensic downloads?
We do. We have detectives that work for the Polk County Sheriff's Office that handle the downloads for us, yes.
Tell the jury a little bit about what they do to accomplish that.
So they use programs such as Cellbrite to hook the phones or devices up that we take into our possession, and then once they hook these devices up, it starts to download the data off of those devices, and then they are able to attach it to like a USB or a CD and provide it to us, and then we are able to see what's on that device.
Sometimes are there limitations to what can be obtained from a cell phone?
Yes.
Sometimes are you guys able to get basically a full copy for copy, meaning whatever was on the cell phone, you can get all the information off the cell phone?
Yes.
Sometimes are you able to only get partial information from a cell phone?
Yes.
And does that basically just have to do with technology or some type of impediment to getting further information from a cell phone?
Yes. It depends on whether or not the program has downloaded or has reached a certain spec for that phone or computer.
Now, can a similar logistics be taken care of on a computer as well, downloading information off of a computer?
Yes.
Now, in this particular case, did you obtain cell phones from the defendant?
Yes.
You or somebody from your agency, of course?
Yes. I had another detective on scene with me that was able to get that cell phone.
And the defendant's cell phone came from his car, is that correct?
His car, yes.
And were you able to obtain the victim's cell phone, Kathy's cell phone?
Yes, we were.
And was that from the island in the kitchen?
It was in the kitchen, yes.
And then were you able to obtain the grandmother, Susan Detman's cell phone?
Yes.
And did she basically consent or allow that to happen?
Yes, she provided full consent to search her cell phone, written permission as well.
Now, were you able to get information / the downloads from Susan's phone?
Yes.
What about from the defendant's phone?
Yes, I was.
And what about from Kathy's phone?
Catherine's phone, not so much. It was a newer type phone that the program was not able to do a full download. So we sent that cell phone off to Homeland Security, where they have more advanced equipment, and they are in the process, as we speak, of attempting to download that cell phone for us.
At some time during your investigation, did somebody bring you Kathy's computer,
Yes.
personal computer?
Yes.
And who brought you that?
That was her oldest son, Christopher.
And is that also the defendant's older brother?
Yes.
Do you recall approximately how many years older Christopher is than his brother, the defendant?
A couple, maybe 4, I believe.
Now, as it pertains to this case, it was Christopher Griffith, not totally irrelevant, but was he kind of had nothing to do with this case?
Yeah, he didn't have anything to do up to that point.
Now, when you obtained the computer through him bringing his mom's computer in, did you have your people attempt to get a download from the computer.
Yes.
And what happened?
We were not able to access the computer
Do you know why?
based upon the passwords or the protection it had on the computer wouldn't allow us to do a full download.
Sometimes our computers and or cell phones difficult or impossible to get into.
Yes.
Sometimes does it have to do with whether you have a password or what make of the technology it is?
Yes.
So even though you weren't able to get into Kathy's phone, is it a fair statement that you were able to see a lot of her activity through the defendant's phone and Susan's phone?
Yeah, I was able to see all activity that she had through the defendant's phone and her mother's phone, yes.
So for instance, if Kathy texted her son or texted her mom, you'd be able to read those text messages as if you had Kathy's phone, correct?
Correct.
And any photographs sent back and forth or call logs or things of that nature you'd be able to see on other people's phones that communicated with her?
Yes.
So was that helpful?
Yes, it was.
Now, during your investigation of the different cell phones, did you come across photographs of the defendant and his mom and Susan?
I did.
In terms of the positives of the family dynamics, what did you learn about, from the photographs, what did you learn about that relationship between the defendant and his mom and Susan?
Well, just by the photographs, they appeared to be a happy family. Looked like they traveled a lot, visited a lot of locations, Disney World, cruises, the White House, it looked like. Looked like they were happy.
Detective Peters, did you have an opportunity to see a series of photographs in the form of, we'll start with 171, 171A, and 171B?
Yes.
And what about photographs 172 through 178 and 178A through 178I?
Yes.
Your Honor, at this time, the state would move those mentioned exhibits into evidence. And with the court's permission, we'll publish those photographs. We could go first to 171. What did you learn from that picture?
Looks like they took a selfie, the victim and the defendant, maybe on a cruise. Looks happy.
171A.
Looks like a mother and son, happy, taking a photograph.
171B.
Selfie, mother and son, happy, smiling.
And in that photograph, does it appear that Kathy has AirPods in her ears?
Yes, it does.
And they're white in color?
Yeah.
We'll continue on to 172.
There's a nice photo. Looks like a mother and son happy there.
And through the Cellbrite report, were you able to determine some of the dates of the originations of the photographs, that being in 2023 and 2024 throughout the different months?
Yes, sir.
Continuing on, 173. Who's pictured in the middle between Kathy and her son?
That is Susan Detman. That's the grandmother and the mother of the victim.
Would she periodically travel with them as well, do you know?
Yes.
174, 175, 176, 177, 178, 178A and 178B. So far, these pictures, is it a fair statement that it's showing different locales and different places that mother and son had been together?
Yes.
178C. And it looks like they're in some type of courtroom or courtroom setup. Is that correct?
It looks that way, yes.
And this circular seal there, maybe you can see it on your computer. What is this?
This is all.
No? All right, no worries.
It's not working.
Looks like it says, well, it does say, Stetson University College of Law. And once again, when there's a third person in these photos, is that Susan?
Yes.
178D. Does that look like it's at Disney or outside of Disney?
Yes, it does.
And for the purposes of the record, in a lot of these pictures, both the defendant and his mom appear smiling and happy. Is that correct?
Yes.
178E, 178F, 178G. Where does that look like it's taken?
Looks like it's taken at the Capitol in Washington.
178 next, H, and then 178I. All right, thank you, John. So some of those photos were from, according to the Cellbrite report, correct me if I'm wrong, were from as early as April of 2023, looking like it went until June of 2024.
Yes.
Now, Detective Peters, did you find out that Kathy had Ring video capabilities inside her residence?
I did.
Was it both inside and outside?
Yes.
And describe to the jury some of the camera locations and what vantage point that would provide.
So there were 4 total Ring cameras that I gained access to. One was the doorbell that was outside. One was in the living room that encompasses the whole entirety of the living room. One was in the kitchen. One was in the victim's room, her bedroom, and one was in the defendant's bedroom.
Did you find that a little bit odd that there were so many cameras in so many locations within someone's private residence?
Initially, I did, yes.
And based on your investigation, were you able to determine why there were cameras inside?
Yes.
And what was the reason?
His mother was a...
Just a speculation.
Are you, without answering the question, but are you speculating or do you know from your investigation?
Judge, I'm going to object. I think I know where this is going. And
Prototype argument. You may continue.
All right, thank you, Your Honor. During your investigation, were you able to obtain Ring camera footage from the interior of the house?
I was.
And is that like a consistent 24/7 recording, or is it something else?
It looked like it was based on movement, and a lot of the times and the stamps were based upon movement.
So is there plenty of times when people are doing nothing of significance, such as moving around the house or just having regular conversations, things of that nature?
Oh, yeah. A lot of the times it was like that.
If the jury, if during this trial I put on every single minute of Ring camera footage in existence, would we be here for hundreds of hours?
Yeah, days.
All right. Now, was one of the rooms that you were able to get camera footage from the camera set up somewhere in the kitchen?
Yes.
And would that point out to capture both the kitchen and then the living room that's behind the kitchen?
Yes.
And then was there a similar camera in the living room that pointed out to the living room, and then behind the living room, the kitchen?
Yes.
And is there a lot of, like, audio-wise, is it a fair statement that there's a lot of things that you can hear clearly?
Yes.
And then are there some things that you just can't hear too clearly?
Some things are muffled, yes.
Have you had an opportunity to, of course, provide all that Ring kitchen video footage?
I'm sorry, what was that?
Let me repeat that. The Ring video footage that you provided, have there been 2 exhibits prepared by me?
Yes.
All right. And do those represent September 7th of 2024 and September 8th of 2024?
Yes, it does.
And for the record, Your Honor, that's State Exhibit 197 from the September 7th, 2024 date, and Exhibit number 198 from September 8th of 2024. What's the significance of September 8th, 2024?
There is a lot of dialogue back and forth between the victim and her mother and her attempts to make contact with the defendant.
And was that the date that she was ultimately killed?
Yes, it was.
That would be a Sunday?
Yes.
And on the September 8th video clips, is it a fair statement that the defendant is not in them because he's not present at the house?
Correct.
Were you able to determine the last day that he was at the house?
Yes.
Go ahead, what day was that?
It was September 7th.
Does September 7th capture some of his interaction with his mom?
It does.
Now, during your investigation, did you come into contact with the name Jeffrey Rapkin?
I did. Yes.
And who was that?
He is the attorney for Collin.
As it pertained to the DV battery case and maybe some family law logistics?
Correct. I learned that he was appointed his attorney. They hired him for the domestic violence case from November of the previous year.
And was there many conversations in text format between the defendant and Jeffrey Rapkin?
Yes.
Was there also conversations between Susan Detman and Jeffrey Rapkin?
Yes, there were.
Now, at some point, did you come across what was basically kind of like a photo icon of a business card of Jeffrey Rapkin?
I did.
And do you recall how the surrounding circumstances of how that came to your attention?
Yeah, looking through the grandmother's phone download, I observed it in her photographs.
All right, so when you click on it, it basically blows up in size to look like a business card?
Correct.
Your Honor, at this time, the state would move State Exhibit 187 into evidence.
No objection.
It was received.
I'm not sure if it's on there. This is useless. Now, based upon that, were you able to determine that the attorney was based out of Port Charlotte,
Yes.
and also Port Charlotte is the city where Kathy resided with her son?
Yes.
Also, were you able to figure out that the phone number 941-916-4096 was the cell phone number of Jeffrey Rapkin?
Yes.
And was that number the number that the defendant would communicate with via text message?
Yes, it was.
Was there a certain time, Detective Peters, when that phone number of Jeffrey Rapkin was in the defendant's phone, and at the top of the phone where somebody's either phone number or contact would be, it was the actual 10-digit phone number?
Yeah, just the phone number, yes.
And then at a certain point, was that phone number saved into the defendant's phone so it said Jeff Rapkin or Jeffrey Rapkin?
Yeah, it appears as if it was saved. The number was saved to a name.
But either way, it was always the same phone number, that being Jeffrey Rapkin's phone number, correct?
I believe so, yes.
And were you able to determine that through the many, many conversations that there would be points when Jeffrey Rapkin would address the defendant as like, Collin, blah, 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 or he would make comments and then say Collin to make it explicitly clear who the two people communicating were?
Yes.
Now, I want to talk a little bit about the relationship between Kathy Griffith and her son, Collin Griffith. With a yes or no response, if possible. Was there an extended period of time, like approximately 3 years or so, where the defendant was living with his dad out of state?
Yes.
And at that point, did Kathy have limited or basically not much at all contact with her son?
Limited contact with her son, yes.
And did it appear from your investigation that she wanted to have a lot more,
Yes.
but that the defendant's father was difficult, to say the least?
I don't have proof that the defendant's father was difficult. I have conversations between Collin and his mother while he lived in Oklahoma, and it did not appear as if it was a difficult situation to communicate with him, no.
All right. Now, at a certain point, did the defendant come to live with his mom?
Yes.
Now, at that point, had she basically missed out, and the defendant had missed out on about 3 years of relationship, mother-son relationship?
Yes.
Did they live in the Port Charlotte house basically up until this incident happened?
Yes.
Now, were you able to determine that did the defendant have his own bedroom at his house?
He did.
And did it appear that he knew the defendant, that there were Ring cameras in the household?
It did appear that way, yes.
And tell the jury about the things that indicated that.
When he would walk in a room where there was a camera, he would look directly into the camera.
And the cameras themselves, are they like hidden in something?
No, they're in plain view.
What cell phone service did Kathy and Collin have?
They had AT&T.
And in order to have AT&T cell phone service, how old do you have to be?
18 years or older to purchase your own line or plan through AT&T.
Judge, I'm going to object to the foundation. I'm not sure how he has this information.
It's the same if you lay the appropriate evidence.
Now, how were you able to determine that Kathy had AT&T?
We have analysts that work with us through the course of our investigation that are able to determine through their programs that they utilize, phone numbers that we give them that provide them with that information.
And during the phone forensic investigation, are there various screenshots that Kathy sent to, at least to Susan, maybe to the defendant as well, that basically said AT&T.com phone records with call history?
Yes. Yes.
Now, in the Ring video footage, is it apparent sometimes that the defendant is walking around with his cell phone that his mom provided?
Yes.
And then that
Back
self.
to the statement about that his mom provided, there's been no evidence.
Did his mom provide him a cell phone?
Object as to knowledge, foundation.
It's the same.
Well, he either knows or doesn't know.
You're gonna lay the predicate.
Okay. Are you aware from your investigation that the defendant's mom provided him a cell phone?
Yes.
Now-
Objection to the foundation.
It's the same.
How,
We've had this discussion.
could you explain how you determine that?
Through the video, she has access to a cell phone and advised in numerous videos that she was cutting off his service.
But Judge, that still doesn't,
Approach. Ladies and gentlemen, I'm going to ask you to step into the jury room for a few minutes while we get some electronic equipment fixed and I address the matter with the lawyers.
All rise, please. May be seated.
All right, Mr. Levine, if you would conduct a proffer.
You said to go ahead, Your Honor?
Yes, go ahead.
Okay.
And, sorry, we're going to try to get him to fix that while we're doing this. if
Oh yeah,
all
that's
right.
fine. That's fine.
Detective Peters, were you able to establish that you were mentioning earlier about your analysts can pull up the phone number and then see the corresponding who the phone provider is. Is that correct?
Yes.
And you had access to the defendant's phone number and to Kathy's phone number, correct?
Yes.
As it pertained to that.
Yes.
And were you able to determine who the provider was?
AT&T.
Now, correct me if I'm wrong, but before the break, what was it that you were answering, subject matter-wise?
How I knew that Kathy had purchased the phone for him.
All right, I'm going to ask you some specific questions about that subject matter.
Okay.
Now, the judge has heard at a prior hearing earlier this month, but so the record's clear during this trial. Do you recall that there were 3 photographs that were sent from Kathy to her mother Susan that were related to this Jeffrey Rapkin text message between the defendant and Jeffrey Rapkin subject matter?
There were.
And was the date February 19th of 2023 that it showed up on Susan's phone?
Yes, that's the stamped date in her photographs.
And those photographs, were those photographs of what appeared to be the defendant's actual phone?
Yes.
And in order for that to happen, that would mean that Kathy would have had the defendant's actual phone and the phone was open, correct?
Correct.
So the defendant's cell phone screen was visible with the defendant's content open, correct?
Yes.
And in those 3 photographs, is it a fair statement that Kathy has taken a picture of the defendant's open cell phone?
Yes.
One of those photographs has to do with the subject matter that the judge heard middle of January as it pertains to the defendant talking about giving his mom the old knife to the neck from behind routine.
Correct.
Another one of those photographs has to do with Jeffrey Rapkin talking about how well versed in the law the defendant is, correct?
Correct.
And Jeffrey Rapkin addresses the defendant by saying his actual name, Collin, correct?
Yes.
On one or more occasions in those 2 text messages, correct?
Correct.
The third photograph that was also sent on that, or that was also showed up on Susan's phone on that same February 19th of 2023 date, was that another photograph of the defendant in text messaging Jeffrey Rapkin.
Yes.
And those 3 photographs had Jeffrey Rapkin's phone number at the top, correct? So it was clear. I mean, the phone number that the defendant was communicating with was Jeffrey Rapkin's phone number, correct?
Right. The first one had his phone number, and then the other 2 had just Jeffrey Rapkin's name.
And when somebody initially calls someone, if they're not saved under a name, it'll be the phone number that they call them at, correct?
Correct.
Or text them at?
Correct.
And if someone takes the time to, over the course of a relationship, take the time to type in the person's name, it's still the same phone number, but now it'll be associated with just a printed name.
Right. You're an established contact at that point.
But other than the established contact, the phone number remained the same. It was Jeffrey Rapkin's.
Yes.
And he and the defendant would communicate, and Jeffrey Rapkin would say Collin a lot, like either Collin and then make a statement, or make a statement and say Collin, correct?
Yes.
Is it a fair statement that from the content it was clear that it was the defendant and it was Jeffrey Rapkin
Yes.
communicating? Now, on one or more of those 3 photos I'm talking about here, what did you notice about where Kathy was when she took a picture of the defendant's open cell phone with the defendant's open visible screens with the text message at issue here?
Well, the last text messages I observed, it appeared her to be holding the phone, and then I could see past the cell phone in the background. It looked like her rug on the floor of her bedroom.
And you were able to actually visually see that rug, and correct?
Yes.
And you knew that from being at the house?
No, I knew that from observing the Ring video that was in her bedroom.
Now, was there multiple text messages, and we'll get into some specific references, but were there multiple text messages where the mom would be talking about turning off Collin's cell phone part of the plan?
Yes.
And that would be specifically related to his number on her plan, correct?
Yes.
Would she make that statement to the defendant sometimes?
Yes.
Would she make that statement to Susan sometimes?
Yes.
And did she make that statement then? And those were like in text message forms, correct?
Yes.
And she also made that statement to her, and Susan made that statement to a Charlotte County Sheriff's Office deputy on the night of the domestic violence battery, when they were explaining that the mom was telling Collin that she was going to be instilling some new parenting and was going to take away his cell phone privilege and his Xbox, correct?
Right. So I've read, yes.
Were there also multiple occasions where she told the defendant through text message and perhaps other forms too that she was going to be changing his phone service so he could only receive phone calls and text messages?
Yes.
Were there multiple text messages where the mom and the defendant were talking, or the mom and her mom were talking about the defendant's phone service actually being off so that he would have to use Wi-Fi to try to use anything?
Yes.
Were there multiple text messages where the mom told the defendant to give her back the phone that she bought for him?
Yes.
And that's the phone that he was using, correct?
Yes.
And that's the phone that was found in the defendant's car, correct?
Correct.
In addition to that, did the mom buy the defendant a MacBook for college courses?
Yes.
And could that MacBook, or was that MacBook mirrored with his cell phone?
You can do that, yes.
And when that happens, what happens?
Your text messages will display in your MacBook like they are in your cell phone.
the defendant at the whole time during this case was a juvenile, correct?
Yes.
And is it a fair statement that it's the mom's responsibility to supervise what he's doing?
Yes.
And it would be common and even encouraged for a mom to monitor and know what their child is looking at or doing on a cell phone?
Very common.
And in fact, the defendant was aware of that, correct?
Yes.
Objection. How would he know?
In terms of the mom supervising the defendant in many or all aspects of his life, was the defendant aware of that? I'm not talking about the phone specifically, but other, like the Ring camera footage, her parenting him, her providing the phone for him. Was the defendant aware of those things?
Yes.
On September 7th and 8th, in the Ring videos in the house, the defendant, he has a cell phone in a black case, correct?
Yes.
Which appears to be the same cell phone in the black case that was found in the defendant's car on September 8th, correct?
It appears to be, yes.
Which appears to be the same cell phone in the same black case in the photographs that Kathy took of the defendant's cell phone when it was open and in her possession, correct?
It appears to be, yeah.
And that has to do with the old knife to the neck from behind text message, correct?
Yes.
And there's approximately 35 pages of a Cellbrite report where the defendant is texting with Jeffrey Rapkin about different subject matter, correct?
Yes.
On pages 3 to 4 of that, the defendant texts to Jeffrey Rapkin, "This is Collin, I am 17," correct?
Yes. Yes.
And did it appear that the mom actually had the ability and did turn off the defendant's phone and control the service?
Yes.
And when mom had the defendant's phone and it was open, it's quite clear that the phone was open, so she didn't need to do anything, correct?
Correct.
And if it's her phone, she can do whatever she wants with it in terms of getting into it or using it, correct?
Yeah, sure.
From the defendant's phone, did you find a conversation with his mom on September 7th, 2:15 p.m. when she said, "Please return my cell phone and MacBook that were purchased for your education"?
Yes.
On page 1 of the text messages between the defendant and his mom, did the Miss Griffith text him, "I'm turning the phone off"?
Yes.
And I understand you might not remember the pages and whatnot, but
I remember the text message.
Okay, I'm mentioning these page numbers based upon what I saw. On page 4 of 8, did the mom text her son, "Your phone service is disconnected"?
Yes.
On page 8, did the mom text her son, "You have 5 minutes before I deactivate your cell phone"?
Yes.
On page 1 of 29, did mom text the defendant, "I'm turning the phone off after this. Please return my cell phone and MacBook"?
Yes.
And regardless if she was going to follow through with her threats, the defendant obviously knew who controlled the cell phone, correct?
Yes.
Judge, I'm going to object to that statement because there's a difference between the service and the actual phone.
On page 1 of 29, Kathy texted him, "I can see everything you're doing from your phone. Try calling Detective Lacey again or my mom." Is that correct?
Yes.
On page 14 of 29, the mom again says, "Your phone service is being turned off." Correct?
Yes.
On page 5 of 29, the mom texts her son, "Closing your BOA account." I don't remember if it said BOA or Bank of America. but-
BOA.
Okay. Indicating that she had joint custody or joint control of his account since he was a minor, correct?
Or access to it.
Or what?
Or access to it, yes.
Access to it, okay. So that's another indication of something she had access to besides his phone?
Yes.
Page, I don't remember if I just said this, but page 14 of 29, your phone service is being turned off. Another statement she made.
She said that multiple times.
Okay. Page 16 of 29, I'm still tracking you and your location, Collin. If I don't see your dot moving on a map towards home, and then whatever else she said.
Yes.
Indicating that she's able to track him through the phone that she so graciously provided.
Yes.
17 of 29, you are reading each message I send. I keep seeing read next to each text I send. I'm shutting your service off.
Yes.
Page 18 of 29, I'm looking at your phone records, correct?
Yes.
Page 22 of 29, your call records with AT&T You didn't even attempt to call Monique.
Yes.
And then, is it a fair statement that Kathy attaches ATT.com screenshot of the records/phone calls for September 6th through September 8th of 2024 that the defendant was either making or not making?
I do remember seeing that, yes.
Page 24 of 29, continuing with the text message conversation between the mom and the defendant. And you are at her house on Wi-Fi because your service is disconnected. Do you remember that?
Yes.
Page 23 of the Cellbrite report from the conversation between now Kathy and Susan Detman, her mother. Do you recall Kathy saying, Collin's phone will not be turned back on given that he lost his phone privilege when he hung up on me?
Yes.
Coming in the home stretch. Page 29 to 30, the same Cellbrite report. Do you recall mom sending Susan Detman screenshots of the defendant playing video games, kidnapping and killing people?
Yes.
The mom was monitoring what the defendant was doing in various aspects of his life.
Right.
And is it a fair statement? Didn't she also text the defendant, I can see what you're doing playing the video games?
Yes, she said it on the Ring camera as well.
Okay, so that's captured there as well?
Yes.
During your investigation and your interview of Robert Wolantis on page 7 of 16 on one of the two interviews, Robert Wolantis told you Kathy did get Collin a phone. Do you remember that?
Yes.
Page 3 of Amanda Friends' 6-page report, she annotated that the mom took the defendant's phone away, and the defendant also told his dad that his mom took his phone away.
Yes.
Page 3 of 6 of Amanda Friends, former DCF CPI investigators noted or commented that mom took Collin's phone away.
Yeah.
Is it true that the mom would take away the defendant's cell phone and AirPods as punishment for being disrespectful to her?
It appeared that way, yeah.
And from your review of Deputy Alexander Sharp from the Charlotte County Sheriff's Office, who he actually testified today, page 4 of 6 in his report, he indicated that the mom told Deputy Sharp she was telling the defendant she will be making changes to his phone so that he will only be able to make phone calls and send/receive texts.
Yes.
Is there any other information or evidence that you have to show about the inquiry of that the mom provided the defendant his cell phone and the defendant was aware of the monitoring that pertains to, obviously the whole relevance of this is the defendant sending Jeffrey Rapkin the text about giving his mom the old knife to the neck from behind routine if she comes up with a gun or something like that.
Right. Just everything we've gone over.
Okay. Judge, I have nothing further for the proffer.
Two questions and then Detective Peters, let's start with the photo of the phone that appears to be the defendant's phone because it's an iPhone in a black case, right?
Yes.
But you didn't look at a serial number. That's not in the picture, right?
Yeah,
That
through the
Kathy-
photograph? No, ma'am.
Right, and there's no other distinguishing marks that indicate that it is the same phone that you collected later that belonged to Collin.
Other than it's very similar in size and the case.
You know how many of those kinds of phones have been sold?
Countless.
Yeah. Okay, so you also mentioned that the phone was obviously open when somebody took a picture of it.
Yes.
But you don't know how it got open, do you?
No, ma'am.
You don't know if Collin was asleep and mom crept in and took the phone from his room to take that picture,
No,
right?
ma'am. No, ma'am.
And you don't know if it was password protected, but she somehow figured out his password against his wishes.
I don't know that. No.
When Kathy texted all these things on September 7th and September 8th about cutting Colin's cell phone service off, she was referring to the AT&T service, correct? At least so far as you know.
Yes, yeah, I would assume yes.
And Mr. Levine has pointed out throughout the trial that minors cannot open an AT&T account on their own. Are you aware that that's true or not?
From my understanding and experience, yes.
Okay. But does Kathy opening an account for Collin prove that she had allowed access to every personal thing on the phone?
I don't know the circumstances in that household. I can tell you I have the same service with my children, and I do have access to all of their stuff.
Right, and you can agree that some families are more privacy-oriented and some are not, right?
I don't know. Based on age, I would say no.
Do you know of any families whose parents don't go through their kids' text messages?
No.
Really?
Yes, ma'am.
Well, I'm going to testify right now that I never went through my son's text messages. At any rate, you said that the photo of the... actually, never mind about that. The text message from Kathy saying, "Give me the phone and MacBook that I bought for your education back." You have no idea where the funds for those things came from, do you?
No.
You're aware that Collin had a trust as a result of the probate from Oklahoma, right?
I am aware, yes.
And that was the source of almost everything that Kathy provided for him of substance.
I don't know that.
Okay. You saw texts between Kathy and Susan regarding getting Shelley, the lawyer in Oklahoma, to
Correct.
send money to
Correct.
an account to pay for things, right?
Yes.
Right. Including for the computer that she was supposedly going to buy. They were talking about how much it costed and that they needed to get the money from Shelley.
Yes, ma'am.
So for all you know, that phone was bought with money from Collin's personal trust.
I can't testify to that because I don't know how
And
that was purchased.
And you're aware that Kathy made things up all the time.
Sure.
Yeah,
Yes,
including
ma'am.
from the text messages around the same date and time that you were just discussing.
Yes, ma'am.
I don't have any other questions.
Anything else, Mr.
Yes, just so I can read the text messages which Your Honor has seen at the prior hearing into the record. It's very short. And for the record, it will be, if Your Honor rules that...
Why do I need to hear those again?
What's that?
You're talking about the actual text from Collin and Mr. Rapkin?
Allegedly.
Yes, Your Honor. I just wanted
I don't
to...
need to hear those for purposes of the proffer.
Okay.
The proffer was to determine this preliminary issue.
Okay.
But Ms. Thornhill, it occurs to me in this hearing, we're focusing a lot on who pays for the phone or what are the source of the funds for the phone. The real question, the basic question, is whether your client knew or should have known under these circumstances that what was in his phone will stay in his phone and would not be accessible to anyone. And what I'm looking at here is what appears to be, the Griffith household looked like a surveillance state to me, and she was definitely surveilling everything he did, not just actually, but constantly on his back about what he's doing, what he's not doing. A parent has a right, even if the object is purchased by the child and owned by the child, stolen by the child, whatever it is by the child, to examine those items. A child doesn't have that kind of right to privacy. The child has a right to confidential communications with his lawyer.
Right.
But under these circumstances, could I actually say, even if she hacked into his phone, knowing what he knows about his mother, that he had no reason to think she might go snooping in his phone, especially given the animosity is not the right word, but the tumultuous relationship that he had with her and the heavy hand that she had on his shoulder.
Judge, I don't think there's been any proof one way or the other. And the burden is on the state to overcome the attorney-client privilege, which is presumed. And while I agree, ring cameras in every room, there's still nothing other than these text messages from months later that are not between lawyers and clients saying, I'm watching what you're doing. And then after she said that, I don't remember if it was this time or another time, he blocked her to prevent her from looking. So that to me
I
says that,
haven't heard that evidence.
I thought I presented it at the hearing.
Can you really block your parent? I mean, they can just take your phone. I mean,
Except if he's with,
what legal significance is a child blocking their parent? When
I
it
don't
comes to the parent's right to inspect the contents of their child's possessions.
but and I don't even concede that there is a right to inspect private communications.
A parent,
Does that,
you don't think, I know you've chosen that route. I might be somewhere in the middle, because I do think it's important to let your child have some privacy, but it's also important to know what your child is doing. But the bottom line is, what matters is what the law says. Are you telling me that the law affords a child some right against unreasonable search and seizure by their parent? You just leave attorney-client privilege aside. But I come home with some object that they didn't provide to me. They don't have a right to come in my room, look at it, see what it is, open it up, read it if there's something inside.
well, Judge, I think that cell phones are innately different. And I don't have the case sites for all of the Supreme Court decisions talking about how uniquely private cell phones are.
Children's cell phones,
Children have a right to privacy.
from their parents?
Yes,
Show me
I
the
believe they
case.
do. I don't have one right now. Oh, yeah, okay. Mr. Hendry is dead on, and because he's practiced family law and I haven't, but even in family law cases and custody cases, sometimes parents are actually explicitly banned from looking at communications between their own child and the other parent.
But that, Mr. Hendry, I think has to do more, I mean, at that point, a court has intervened because there's an issue that needs to be resolved regarding the best interests of a child, and those orders are typically not put in place unless you have parents who are interfering with the other parent's time sharing and rights to the child. So that's not so much to protect the child per se, it's to protect the relationship between that child and that parent, to prevent the other parent from interfering. That, I don't think that's the same.
But Judge, isn't the relationship between a client and their attorney sacrosanct?
That's the second question. The first question, I mean, it's analogous to talking at the restaurant to your lawyer at a volume where someone else can hear. You knew or should have known someone else would hear that. It's today's version of that. If you're texting under circumstances where you knew or should have known someone else is going to read that.
And that's where I think we differ. I don't think that Collin knew or should have known his mom would be reading messages between him and his lawyer. Period. No.
I think that has absolutely been shown in this case that that is exactly the type of person that she is. But you're telling me there's a case that says a child just blanket has this right to privacy as against their parent.
Not a blanket right, Judge. We're talking about very specific circumstances where she is the alleged victim in the case, and this lawyer was hired by his grandmother to represent him in a case against his mother. So even if she is someone who looks in his phone now and then, Collin had every right to expect that the communications that were privileged between him and the lawyer that is representing him against his mother that those would be protected. And I don't know how much more simply I can say it. I think we're making a mockery of the attorney-client privilege if you allow this in, but I understand if that's your ruling. I don't think the state has established the ownership and control to the extent that she could invade, and he should expect that she could invade his
Well, I'm sort of
attorney-client privilege.
receding from that because it's occurring to me during this hearing that I think parents have those rights as against their child, even if it's not their property.
And even if she's the victim, so that's like saying,
But that's a double-edged sword. I mean, you have to take this in the context in which it's arisen, which is he lived in a surveillance state with his mother.
therefore he doesn't get to have.
No, therefore he gets to walk down the block, take a jog, call his lawyer, where she can't hear it. That's what I'm saying.
Okay, well, we obviously disagree. I don't think this is the same as speaking in a loud voice in a public restaurant. I think that there was an expectation of privacy and privilege that the state has not overcome, but I don't think there's much more argument to be made about it. Sorry.
Under the circumstances where we're operating, where he has no right to make a phone call within his home, but his mother also controls all of his assets and all of his belongings, how is he, I mean, we can set the hypothetical where he goes on a jog and makes a call, but if we're also conceding that mother has the access to turn off his account, how does he ever get a confidential communication if he's a child? If he's stuck inside of his home with his mother controlling every aspect of that life, and then we're to say, well, anything he does inside of that home cannot be confidential because he's in the home and he knows that it can't be confidential, then we just become, it's a circle where we're never allowing Mr. Griffith any privacy.
And he would have to rely on his mother to take him to the office of Mr. Ratkin.
He couldn't make a call in his room under these circumstances. She had a Ring camera in his room, which would be an invasion of
I
privacy.
agree.
And I didn't realize that there was a Ring camera in his room because I haven't gotten any footage from that. I thought we just had the kitchen and the living room. And the doorbell, sorry. It was clear from one of the body camera footage things that it says something you can tell she has a Ring doorbell.
So, Mr. Levine, what I'm hearing is I'm looking at this with too narrow of a view that what is a child to do in the circumstance where confidential communications with their lawyer either happen at the whim of the parent or not?
They don't, Judge. Your decision, and obviously you make the decision, but where you were headed and what you were saying makes complete sense. I haven't said a word over here. The more the defense just keeps talking doesn't mean they're making more of a point. You shouldn't change where it appears you were going to, because you're supported by the law, you're supported by the facts, the proffer, the law, and what you've been saying justifies you allowing this to come in. But you're said it yourself, the first thing. He wasn't held as a prisoner. This guy went out all the time. He could go wherever he wanted to. He had his phone all the time. His mom, despite all these threats, very seldom did she ever cut his phone off or turn off his service. So he could do whatever he wanted to, whenever he wanted to. It's ironic because on the day when he ended up leaving the house, he was too lazy and disrespectful to do some simple chores because he wanted to go take his walk, which is exactly what he did. So he could have done that at any time. Another thing that I didn't mention, but I did mention at the hearing, is that so I think you're spot on. I think the evidence is spot on. My arguments and the evidence as presented would justify you allowing this in. To do anything to the contrary would seem to go completely against what your gut instinct and the evidence has shown. Furthermore, one of the things I mentioned at the hearing was, it sounds like, the attorney's making the argument for the defendant. And of course, she has the right and she should do that. But what I said about, what I cited some of the case law and some of the propositions are, it's what was the defendant's intention and belief about, if this is one of many things. This is just another thing that would support you allowing this in. But one of the things is, what is the individual's belief or thought process when they're having a conversation with an attorney? And you have to look at that through the individual, not some educated attorney who's been practicing law for decades and legal arguments and things that they're making and how their mind works as a seasoned attorney. But you have to look at it from the defendant, a 16-year-old who's talking about giving his mom the old knife to the neck from behind, which is how he killed her. When he's having a conversation with Jeffrey Rapkin, he's not sitting there thinking, oh my God, this is definitely going to be protected as the attorney-client privilege. No one's ever going to see that. He could care less about that. What he was thinking was getting information from his attorney and what he might do in the future, which was he would be happy when he had the chance to kill his mom and set it up, just like he did the same thing with his dad. But when he sent that text, I guarantee you, when I would say the evidence supports this, and it's one of the considerations you should make, that Collin Griffith, the 16-year-old or 17-year-old, wasn't even considering the attorney-client privilege and wasn't thinking, this will be protected, nobody will see this. So that just goes to support what Your Honor should do, which is allow that to come in. There's nothing more humanly possible I can do.
Well, you're
under these
asking
circumstances.
me to let it in under crime fraud exception,
No,
and
I
we've
don't-
talked about that.
No, I don't. You've already addressed that.
That is much less clear in this case.
That's not what I'm asking to let it in under, because you've already made that ruling. That should said a long time ago.
I mean, it is. I cannot say to a level of that you've shown to the required level preliminarily that the crime fraud exception applies based on the context in which this lawyer was representing him and what appears to be, although eerie, and we've all recognized that, appears to be a discussion about what can I do to protect myself.
No, and the way I'm thinking about it, you've already made that ruling last time, so I'm not arguing that today, but what I'm saying is you can and should consider it in terms of when he's making this text to his attorney, he's not thinking, Collin Griffith, the 16 or 17-year-old, is not thinking this will be protected by the attorney-client privilege. I feel safe in doing this. Whereas if Ms. Thornhill or Mr. Henry wrote the same text or a text like that, then their adult, intelligent, educated minds would be thinking about this would be protected. But you have to look at it through the defendant's point of view, and the last thing on his mind was the attorney-client privilege.
Thornhill and Mr. Hendry.
I mean, under that logic, then we're providing less protection to a child for attorney-client privilege because they're less sophisticated and less smart than an adult. That goes contrary to the law. That goes contrary to how we treat children in this justice system. We give them more protection and we give them more leeway. To say that they're not sophisticated enough for an attorney-client privilege it's wrong.
I'm not persuaded by that, but I mean, I think there's probably a lot of adults that's not what goes through their mind when they're talking to their lawyer, and typically lawyers will tell their clients, what you tell me is confidential. But Mr. Levine, all right, we're going to take 5 minutes.
All right.
Losing my voice, so just a moment. All right, we're back on the record. Mr. Griffith is present with both of his lawyers. Mr. Levine is here for the state. You know, there's a bigger question here that I don't know if there's any law on that occurs to me based on the arguments made by the defense, aside from the more specific question of what the defendant knew or should have known. And the question in my mind is, does a parent, in the context of the attorney-client privilege, or just the attorney-client relationship of their child and the child's lawyer, have some obligation to facilitate attorney-client privileged communications? Meaning, yes, let's just assume that he had some expectation of privacy. Well, strike that. You have said, how is he supposed to communicate with his lawyer if mom can take the phone away? I guess my question to you is, does she have to facilitate it? Is that part of my analysis, that children should have a right to use property that their parents would otherwise have every right in the world? I mean, they could bring a locked chest home and the parent could cut the lock off if you ask me to see what's inside.
If the lawyer's in there and they're trying to communicate.
That's different. Once that relationship has commenced or is in action, the lawyer can prevent that.
Judges, 35
But-
pages of text messages where the defendant had no problem communicating. He didn't need any help from anyone over many, many months, kind of proving that he had no problem getting to talk to his attorney or seen his attorney, and Susan would have taken him there
But
every day of the week.
I think you're missing my question. The communication we're talking about here occurred on a telephone. And so, is that what you're saying, Ms. Thornhill, that I want to get this right, and you're telling me children should be allowed to talk to their lawyers on their phones without having been found to, and imputed knowledge that their parents can get in there and see what they're saying. You're asking me to rule that way.
Yes.
And would that be contrary to the case law that we discussed at the last hearing, and what the court is supposed to analyze in terms of what we've been discussing about?
No one showed me a case about a cell phone and a parent's right to look in there even when it, and to use confidential, otherwise confidential communications. What would be a confidential communication if you were an adult?
No, but as it pertains to the defendant having no right to, no thought process that would even be confidential. And the analogy that Your Honor was talking a little bit about today, but we talked much more in depth about at the hearing, about if you send an email on a company computer, even if it has to do with lawyer-client privilege, and I cited a case, I don't remember the case, but I cited a
But
case.
what's different is that person is an adult and has other means of communicating. This person's means of communicating with his lawyer was a cell phone.
He wasn't locked in a cage, Judge. He was at Susan Detman's house all the time. He was using that cell phone as much as he wanted. His mom made a million threats, but never followed through basically on any of them. He's running around enjoying doing his walks. He was not held captive. He had almost like an adult. He could do whatever he wanted to. He had a driver's license. Susan Detman would
Not
take
when
him.
he sent that message.
All right, fair enough. I didn't remember that. Susan Detman could take him anywhere. Like what I was saying about the 35 pages of text messages, time-wise, like he had his phone and was using it anytime he wanted to. So it wasn't like he didn't have the opportunity. And I don't think that inquiry that Your Honor is talking about most recently changes it one way or another, unless there's some case, which none of us have seen the case that would support what the defense is arguing, case law-wise. So I think, I understand that question might be interesting to Your Honor, but that shouldn't change your mind.
Well, I'm kind of thinking just the hypothetical circumstance. Suppose you have a child who has no other way to talk to their lawyer
But you don't have to worry about that because that's not this
other than
situation.
on a cell phone. Well, I think that's the starting point. What do you do in that situation? Does the parent have an obligation to provide a means of confidential communications with their lawyer?
And it's clear that question could be interesting, and it's definitely interesting to you, and I know you want to make the right decision, but that's not the situation that the defendant was in. And when you analyze that thought that you have, but under the defendant's situation, he's not in a situation like a hypothetical teenager might be.
I appreciate that you think I think certain things are interesting but irrelevant. It's more than interesting to me. It is, I think, the fundamental starting point, and then we break it down from there. You can't answer the question, though. Is that correct? Does a parent have an obligation? Does a parent have an obligation to facilitate, not this defendant, just as a matter of general principle, does a parent have an obligation to facilitate confidential communications between their child and their lawyer?
I haven't seen a case that says that, but by the same token, a parent could do or not do anything they want to. So if they want to be a bad parent and just not help their child in any way, shape, or form, there's no law that I'm aware of that would require a parent to get the child an attorney, or to get the child to an attorney's office, or to help the child in any way, shape, or form. As we've seen with a bunch of deadbeat parents who don't do anything, not in this case, but just in general. A parent could sit back and be completely uninterested in their child's life, and that might not be against the law in the context that you're asking about, if they have an obligation or a legal requirement to help their child have confidential talks with their attorney. So I would say no. I don't believe that there's a legal requirement. I certainly haven't seen a case law, and if there's some legal precedent to the contrary, I would learn something new if that was the case.
You've worked in juvenile. I've never sat in juvenile, but do you know? I mean, I know the parents are, I don't want to say parties down there in criminal cases, but they're always called up to the podium. They're always asked questions, and I think the judge has some jurisdiction over them.
Well, it's the duty of the parents to make sure their child gets to court to deal with any criminal charges or delinquency charges. I don't know that any of our judges have ever punished a parent for not bringing their child to court. So I think there is an obligation of a parent to at least not impede, and concurrent with that, not impeding should also be respecting the attorney-client privilege. I think I mentioned this at the hearing. If I'm meeting a client in the lobby of the public defender's office, a child, and I do that all the time, and a parent says, he's a minor, I've got to come in there with them. I explain to them that, no, you don't. Anything that I say to your client, to your child, and the child says to me, is confidential and protected. The minute I let a third party into that, it waives the privilege. 99 times out of 100, the parent stays in the lobby, and then that 100th time, I say, then I can't talk to your client. To your child. Sorry, I'm getting client and child mixed up. So I don't see how you can recognize that a child does have the attorney-client privilege, the protections that exist.
Well, that's interesting. In that 100th case, then, you are recognizing some superior right of the parent to say, no, you're not going to have confidential communications with my child, because you say, I'm not going to talk to your child.
No, what I say, and it doesn't usually last longer than this one visit, I say, I can't talk with your child about the case in the way that I need to be effective with you present. I will be
So
happy.
you're not ceding to them. You're just
No.
saying, we're not going to do this here.
Yeah. And I also explained to them that I will be happy to answer the questions that I can answer after I've talked with them privately. I don't know how else other to say it than a child had, well, the case law does, I provided that case that talks about children have the attorney-client privilege. It's not superseded by their parents or somebody saying, we need to know where this child is right now. Attorney, tell us where the child is.
I'm not disputing a child doesn't have the right or the privilege. So can you respond to Mr. Levine's suggestion that we're talking about Collin Griffith,
Right.
who had other means, had a car,
He didn't have a car at that point.
had a grandmother,
Who lived in another county.
who he had a relationship with, though, correct? A
Absolutely.
positive relationship.
Absolutely.
And-
But if he's got a lawyer who says, I am your lawyer, I work for you, anytime we talk it's confidential because the lawyer also doesn't know that Kathy maybe is intrusive and hacks accounts and things, and assures Collin,
Well, I don't have that evidence of what the lawyer told him.
you don't have a lot of the evidence that Mr. Levine is talking about either, the claims he makes, and yet it's, the privilege exists, and it's their burden to overcome the presumption of that privilege. I don't know how else to answer the question. If Mr. Levine is trying to say that Collin Griffith knew that this was not a privileged conversation, like he specifically did it knowing his mom was going to look at it, I think that's absurd, and he hasn't established that.
I don't know that I would agree under the circumstances I've heard about this relationship that it's he would have no reason to think his mom wouldn't be snooping around. I don't know that I necessarily agree with that, but Mr. Hendry, you've risen. Do you need to be heard?
A thought occurs that if we're dealing in these hypotheticals, if there was not this screenshot, if they have Collin's phone, Collin is a child, mother has access to this phone, they've done a Cellbrite download of this phone, well, the message exists on the phone. He doesn't have confidential communications because somebody else has access to that device that may have just gotten it in without the mom. I mean,
I think there are some cases that talk about that particular circumstance.
But
I think it's what's in the mind of your client that's important in terms of whether he knew or should have known that another person would have access to it.
But if the access was the same, if mom hadn't actually taken that picture, but he knew that she had access to that phone, even if she hadn't taken that screenshot, would that still not be a confidential communication? Are we saying that anything that happens on those devices for children, they can never be confidential?
Well, that's the question I'm asking.
I just don't think that. I think that's an unreasonable position to take in 2025 when the bulk of communication happens not face to face. There's nothing that supports the state's position that I'm aware of that a phone cannot be confidential. The only thing that seems to be unique in this case is that somebody took a screenshot of a device and then sent it to a third party who, if we didn't have this warrant, I mean, it's not like these things, it's not like Ms. Bettman's on the stand right now testifying to this. We are using a detective who accessed this through a Cellbrite download and a search warrant.
It wasn't, well, I think it's beside the point, but it wasn't a search warrant, it was a consent to search from Susan Devon herself, but be that here nor there.
But this is still, we are not in a situation where somebody was told something and then that person is on the stand saying, hey, I know this information. This is law enforcement gaining something from a search device. And I think that's different. And I think that this is still, to the extent that the child has, confidential communications, child has a right to privacy, but also there's parents' rights, and it's all kind of murky here. I don't think that this communication has been breached from Collin's perspective. And I don't know that Susan or Kathy have the right to breach that on Collin's behalf without him doing it. And that's the ultimate issue here, is did Collin give up his right by putting this communication on his device? Because he didn't give it to anybody else. Somebody went through that.
The question I have is whether he knew or should have known that it wasn't going to be, whether he knew or should have known others would have access to it, a.k.a. his mother.
That is one of the hugest, of course, inquiries, which we've been talking mostly about. The other thing I mentioned which I know you said you weren't impressed by, but you still have to consider what was the person's intent when they sent the message from that person's mind. And I would ask yourself, I would ask you to ask yourself, when Collin Griffith sent that text message, was he thinking this is a confidential communication between me and my attorney? And I would submit to you the answer is no. I would submit to you that the other inquiry that we've been talking about, the evidence that I've presented is evidence to support you ruling this admissible, Your Honor. If your answer is no to the question about whether Collin thought that was a confidential text when he sent it, not now after his damning evidence, and he knows that, oh dang, it's going to be used against him, and his attorneys are obviously bright to know that they don't want this in. It's not how they feel now or how it might look, but when 16-year-old Collin sent that text message, there's no reason that he would be thinking about the attorney-client privilege and that this is protected. So I think those two inquiries are of paramount importance in your analysis.
It's interesting that Mr. Levine talks about how 16-year-old Collin couldn't have been smart enough to figure out that this is a privileged communication when they turn around and also argue that he's got this mock trial paperwork that's somehow informing him about how to make this whole grand plan to lure his mother to Auburndale. So I think that's ridiculous. I think you start with the presumption that it's a privileged communication. The state has not overcome its burden to establish that Collin did know or should have known that he was not making a confidential communication because his mother might be able to someday look at it.
All right, Mr. Levine, you're recalling this detective.
Yes.
Do we have to do this today?
No, Your
Because I want to
No, we don't.
make sure there's no cases on this issue and would ask a related issue, analogous issue, other than just the general proposition that a child has the right to the attorney-client privilege. I recognize that. But it is, as Mr. Hendry said, murky when you're talking about parents' rights and children's rights. And just the basic reality, I think that kids know their parents can look in their phones.
Can, but should.
But the question is,
Or would a child say, okay, there are certain things that my parents should look at, like my internet activity, things like that, to make sure I'm not communicating with sex predators or buying drugs or things like that. But when Kathy sees that it's between Collin and his lawyer, why is she looking at that anyway?
Because she realizes he's going to kill her, and he's talking about how he's going to kill her.
I'm not in any event, you know the issue that concerns me,
Yes.
which is a parent's right. I think it's sort of almost an absolute right of a parent to inspect their children's belongings,
But once again,
and
we added,
the right of a child to communicate confidentially with their lawyer, and those two are intersecting here. And then what a reasonable child would understand under those circumstances when they send a text to their lawyer. You know,
I'll do
I can't
some-
believe that question hasn't been presented to a court before.
I did a lot of research before we even came to the hearing on this. And there are, unless I was using search terms that were incorrect, but I used the 90.50 whatever that talks about the attorney-client privilege and the admissibility or inadmissibility of privileged communications. I did attorney-client privilege with child, juvenile, adolescent. I did it with cell phone, electronic device. I mean, I tried everything to come up with something, and the only things I came up with that were even remotely related were cases that I provided at the hearing. But I'll try again.
There must be some other areas where children's rights versus parents' rights intersect in some more general sense that at least can give us an appropriate framework to talk about.
From an impediment standpoint, this comes up a lot in family law where you have things that are ordered the child to do, and then one parent says no. And then what does that, at what point does the court get to step in and say that's something that we can do something about. So, I mean, that family court is the only area this really comes up a lot in my
I
opinion.
think we
But
have
that's
to
even
be
slightly
careful of
different.
family court because you're really talking about parents not getting along and then having to figure out what's in the best interest of a child. And when parents disagree on things like privacy for their child.
Right.
Because as you say, you and your family, you've decided your kids are going to get a pretty hefty, serving of privacy. My family, they get kind of a moderate serving.
Detective Peters.
Some families, though, I could see taking the position that you don't have a right to privacy in this house at all. I have the right to come in your room, rifle through your drawers, look through your papers, take your phone to the sheriff's office to see what you've been doing. So,
But I think we have an absence of that here. I realize that there are tons of text messages with her saying she's cutting off his service or I'm tracking him. But that's very different from looking through his communications on his
he's
phone.
got a camera in his bedroom, Miss Thornhill. I think that cuts against that argument. I mean, that is the biggest intrusion on his privacy, if you ask me. So
It is
when
a huge
when that's your situation at home, and you've got that cell phone, and you're texting about putting a knife in your mom's throat,
If she
you
attacks him with the
you
knife-
shouldn't have thought twice about that in terms of, is mom going to see that?
So now we're putting the burden on a child to go above and beyond what anybody else would be required to do to keep their communications with their attorney privileged.
That's my question. Where does the parent's right intersect? And that's why I asked this question. Does a parent have an obligation to facilitate that? So we're not going to answer it today. I'm going to ask that you save that for when you recall him. I'd like to hear something in the morning, either just point like, yeah, I stayed up all night and found 0, or see something, and I'm going to research it as well.
And I'm gonna-
Because the question in my mind has changed from what it was initially, which initially it was just ownership and control. I really don't think that matters. I think it's just the child's right to inspect, the parent's right as against the child's right.
And I will also see if any of our public who's
All
have some ideas.
All right.
Because I will recognize my limits in my research skills.
You have some other line of questioning for the detective for the rest of the day, though?
Well, Judge, and another thing that would go into would be the ring videos, but then those are kind of time consuming. So I don't know if you want to stop now, but I think logistically it would make sense to stop now.
How much footage is there,
I was-
time-wise?
It's long.
So more than an hour and 15 minutes?
I just don't remember. I can pop it in and answer that, Your Honor. If you can give me 1 minute, I can pull it up and we'll see.
Yeah, we might get through September 7th, but not September 8th. September 7th is long.
Judge, there's 50 clips, and then each clip,
It's between 3 seconds and 2 minutes.
We've spent a lot of time doing this. I'd like to sort of catch up a little bit if it's not going to seriously interfere with how you're presenting your case. I'd like to fill up a little more time this afternoon.
whatever Your Honor wants.
All right. Does anyone need just a quick bathroom break, anything like that?
I took 1 or 2 minutes ago, so I'm good.
Madam Court Reporter?
I'm good, thank you, Your Honor.
All right. Let's have the jury.
The detective?